Lewis.
Okay, State of Michigan versus Sharonda Lewis, 25-01108. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people.
Assistant Public Defender John Lee on behalf of Sharonda Lewis.
Okay, this was set for review. She was ordered to go to have a forensic evaluation, it appears. Is that what happened? Yeah. And then she's been on warrant status. Did we get a response back from her? Did she ever appear? I don't know that she ever appeared. I signed this. This is from May. You might need a new referral.
Okay, Mr. Milks advised me that she was waiting to be seen while she was in jail. So I don't know if he has been in touch with CFP and that's his understanding, or if he needs a new referral, I'll let him know.
Yeah, my note here from September is that the defendant failed to appear for the forensic evaluation. So I issued a bench warrant with a remand. It's possible at this point we need a new referral. That one was from May, almost a year ago.
Okay. We'll get on that ready.
Oh, any additional matters for today's record?
Not for the people.
Not for the defense.
Thank you.
Thank you.
But then,
You're all set, Ms. Lewis.
do I get out?
Absolutely not. You're remanded until we get a forensic evaluation.
How long is that?
No.
You know when I get out?
I don't know when you're going to get out. You were ordered to do a forensic back in May. You failed to appear. So now we have to wait for your attorney to submit a new referral, and then the forensic center will have to schedule a new evaluation. And I have to hold you in the custody of the jail to make sure that it's done.
I have another court date.
Not at this time. It's going to be set for a review, but the attorney should be getting me this paperwork today for a new review.
I absolutely love it. When am I getting out? I don't know. I ordered you to go for an evaluation. It didn't happen. I don't control when you go for an evaluation. Don't know.
Evaluation.
And then I'll know today. How do I know? They're gonna let me know?
You're not going to know about the forensic until it's scheduled. So you won't get any information until your forensic evaluation is scheduled, and the jail will make you aware of that, okay?
I have to stay here, right?
You absolutely have to stay there until that's done.
Okay.
Thank you.
Thank you.
All right, we are on the record in the matter of Joanne Lindstedt versus David Solden, file 19-33536-SC. This is set for a status conference this morning. Initially, we thought Ms. Lindstedt had failed to appear, but she is here now.
This is all Zach's fault over at Law Nerds Unite. All of it.
In the courtroom with me. We are here today, Ms. Lindstedt, for a petition for order limiting communication and contact with the court and staff filed by the county administrator. You received a copy of that?
Yes, I don't have it with me, but yes, I did receive a copy of that.
I have an extra copy. Do you want to read that now? You want to review that now?
I'm sorry.
I have an extra copy with me. Would you like a chance to review that?
Yes, please. By the way, good morning, Your Honor.
Good morning. Have you had an adequate opportunity to review that?
Yes.
All right. The court administrator is asking for an order which would prevent you from having contact, direct or indirect, with Ms. Good, to prohibit you from entering into the district court building or grounds unless ordered to appear by the court, and to limit your contact with the court to email, telephone, and Zoom appearances. Do you agree or disagree with that request?
I disagree.
Can you tell me why?
Well, for one thing, because because when I would come into talk with Miss Good at the window, I would talk to her, and she had a listening ear, and she was very personable. She has personality. She's a people person, and she would listen to me anytime that I had something going on. That I would talk to her, and she was there for me. And I would give her. I had given her many compliments, and when I did, she would thank you. She said, "I thank you. I appreciate that." And I had given her many compliments, and so on, and she is like a sister to me, and.
Do you recognize that that level of personal relationship made Ms. Good feel that was inappropriate and too familiar? Do you understand what that term means?
I'm having a hard time trying to hear
Do
you.
you understand that Ms. Good was not happy with that level of contact from you?
No, I was not aware that she was not happy about that level of contact.
Do you-
Oh, that's harsh and absolutely accurate. Oh my God. This is what that woman in Colorado needed. She needed that honest, hard truth like this.
You understand that Ms. Payne was the one who then became the person who had contact with you because Ms. Good thought that you were becoming too familiar. You were complimenting, even to the extent of complimenting her eyes, saying that she had nice looking brown eyes and calling her sweetheart. You understand that?
Yes, sir.
You understand that that's inappropriate in a professional relationship. She's not your friend. She's not your comforter. She's not your colleague. She is a person who works for the court, and she cannot have a personal relationship with you, and she's not asked to have a personal relationship with you.
Okay, and on the note that saying that I was not aware in the first place that we're not allowed to give compliments or anything like that. I was not aware of that. I was not told that up front by the courts or nothing, by Pam or anybody. And if Miss Good,
Judge, I skipped kindergarten and all forms of socialization since from the time of birth till present.
thought that I was coming onto her, no, I have more respect for her than that. And I would not ever do something like that because she's a good person. She's very humorous, and she would listen to things that I had to say to her. And she had a very good listening ear.
Okay.
She had a good listening ear and some nice cans, Judge.
Why do you think Ms. Payne was used instead of Ms. Good to have to be involved in your case?
Why do I think Miss Payne was?
Right.
That is a very good question. And there was times too that I would come in and try to talk to Pam, and Pam was she was not very nice to me. She had my anxiety, my depression. It was running high. I even when I tried to talk to Pam, it got to the point where I just couldn't do it no more, and I just took my stuff and I left the building because I didn't want to have any problems, and I didn't want to go from there with it. So that's like the reason why that. And like I said, that Ashley had given me personal information about herself as well. And
Okay, Ms. Lindstedt, there is an email to you from the court administrator dated October 24th of 2025, in which you were informed that your comments to Ms. Good made her feel uncomfortable, and that because of that, she would not be assisting you with court business going forward, and that Ms. Payne, the district court supervisor, would be assisting you. So you were given specific information about that. So you did know that that was the reason why Ms. Payne was up. And then when Ms. Payne attempted to assist you, you made life difficult for her as well, coming in and making scenes in our lobby, coming into the district court grounds, driving your truck around.
All right, we got to give the judge credit here. He doesn't want this crap in his life. He knows this is coming. It's on his docket, and he's like, oh, you've got to be kidding me. I have to explain that water runs downhill in this awkward discussion with somebody who doesn't understand the basics of life. In public, in front of other people. Okay, fine, call him up. He's doing an admirable job.
At your vehicle around at times when staff was leaving. We've had notices from people in the community that you're asking for pictures of staff and that you're making threats to staff, saying that you're going gunning for them. That is totally unacceptable behavior.
How was I making threats to the staff?
Your sister told a relative of one of our staff that you were gunning for one of our staff members.
That was what?
Gunning.
I don't even know what that means.
It sounds like a threat is what it sounds like. So that's why you're here today, because you're acting inappropriately to multiple members of my staff.
I'm not threatening nobody, Your Honor.
Good.
I would not do that. I would never do that because I know that I can get myself in some serious trouble with that, and I would not ever threaten nobody. No way, shape, or form.
Then
No.
why are you asking other members of the legal community for pictures of court staff members?
Why am I asking others?
Oh my
Yes.
God.
I didn't know I was asked. I don't even know who I asked.
You went to a law
didn't
firm
know I
and
was.
asked the secretary there if you could get a picture of Ms. Good because your phone wouldn't work.
I don't even recall that. If I did, I sure don't remember it. No, because that factor and some of them, and I'm gonna put it out there because some of them are on Facebook.
Let me make this very clear. The staff is here not to have a personal relationship with any member of the community as a result of their meetings with you here. They're here for professional duties only.
Okay, I understand that. I won't do anything again, and just give me a chance to prove myself, and I'll go from there. Because I won't.
We did that already when we sent you a notice saying don't have any inappropriate contact with Ms. Good, and then you were unable to have appropriate contact with Ms. Payne. That was us giving you a chance to show that you could do it, and you failed that opportunity.
Can you give me another chance? I mean, I'm gonna try to do what I can, and so on. I mean, I'm trying to be a better person, trying to do as I can, and so on.
I'm simply saying to you, ma'am, that your behavior has been inappropriate now to at least 2 staff members. And because of that, I'm going to enter an order that you have no communication or contact, direct or indirect, with Ms. Good. That you are prohibited from physical entry into the court and onto the court's grounds. That you be limited to contacting the court via email, telephone, and or Zoom. That you shall not communicate or behave towards court personnel in a manner that is invasive, personally invasive, assaultive, threatening, abusive, or intimidating. And this order will remain in effect even after your small claims court case is discontinued. Do you understand? Do you understand the court's order?
Yes, Your Honor. And how long is this in effect for?
It's an ongoing order. So
Judge, when can I start creeping on everybody again? That's all I want to know.
there is no end date.
So I can't have no contact with.
There's no finish line.
You may have email, telephone,
None.
and Zoom contact with the court.
I can't have any of that.
You can have email, telephone, or Zoom contact with the court.
So who are the 2 people that I can't have contact with?
You may have email, Zoom, and telephone contact with the court. You may not have any contact with Ashley Good. That's the only one that you may not specifically and personally have contact with. you understand the court's order? All right, you're free to go, ma'am. Thank you very much.
Okay, good morning, ladies. My name is Judge Ratliff. I will be your judge this morning. As I call your name, you'll come forward just like you did with the clerk. At that time, I'll talk to you about your pending charges that happen in the city of limits of Amarillo, which are Class C misdemeanors, meaning these are criminal allegations punishable by fine only. I'm going to tell you the name of your allegations, their fine range, their court costs, and then your choices. Because you're in jail and because these are criminal offenses, you have the following rights that I want you to understand. So feel free to ask me questions if you have them. First, you have the right to plead not guilty because you have the right to hire an attorney. Ms. Lewis, you may sit down. You don't have to stand up for this. Thank you, though. You have the right to plead not guilty because you have the right to hire an attorney. You may also plead not guilty because it's your right to request a trial in the future by a judge or by a jury. You do have the right to remain silent and not say anything at all. Anything you do say will be used as evidence against you. If you choose to remain silent, I enter a not guilty plea on your behalf. You do have the right to have an attorney present to advise you prior to or during any interviews with the police or prosecutors. You can always end an interview with police or prosecutors at any time. If you're not a United States citizen, you have the right to have your country of origin notified that you're in custody. So as I said, you have the right to plead not guilty, but that means you would have to bond out of the jail. All a bond is it's an extra guarantee for your appearance at my courthouse, not back out at the jail. So as you're leaving the jail and you're signing that bond, on that bond, they give you a court date and time to appear downtown Amarillo at the police department. That's actually the 4th Street side. So you come in on the 3rd Street side of the police department. A bailiff will greet you there and show you to the back of the building that is the municipal courthouse on the date and time of your bond. Don't miss your bond hearing. It's an important hearing where I give you information about how to have a trial, how to see the state's evidence, but most importantly, I give you your next court date. So don't miss your bond hearing because I issue warrants for your arrest if you miss your bond hearing. Your other choice is to say you don't need a trial, you don't want to hire an attorney, and you can choose to plead guilty or plead no contest. Either way, I find that you are guilty, assess the fine and the fine range of the court costs for a total. I do give you credit for time you've served so far. If there's a balance, I'm going to tell you what it is, and you have to appear the next business day after you're released to talk about that balance. Don't miss your jail release hearing just like you wouldn't miss a bond hearing, because the consequence of missing a jail release hearing are capious warrants, meaning the next time you could be remanded to sit the remaining fine and court costs out there at the jail. Now, specifically, Ms. Browning, you do have capious warrant. I'm going to tell you what that total is due, talk about what went wrong. I'm going to have some information from you about your financial ability to pay. But because you have that capious warrant, you are at jeopardy of being remanded to sit the remaining fine and court costs out in jail if you can't pay it. So feel free to ask questions if you have them as I call your name, come forward. Miss Lewis. I know that was a lot of information for you. The charge before the court is called public intoxication. The fine range is $1 to $500. Court costs are $81. Do you feel like you understand your rights?
Yes.
Do you want to plead not guilty because you want to hire an attorney or have a trial?
What's the difference?
Not guilty means you feel that the state, through a prosecutor, should have to prove that you were intoxicated in the public
Correct.
area.
You can stop right there. Correct. Because I was not drinking. I just brought the beer inside Pizza Hut, and it was Ali Allison's son that freaking was working at Pizza Hut, and I was standing outside, and I'm expecting.
You want to plead not guilty to it?
Yes, not guilty. The best solution, because I didn't drink it inside the store that I'm aware of. I did not drink it.
Okay, because when the police officers came, they were
I did not drink it as such that I'm aware of because I was wasted.
really concerned about like how you were acting.
They imitated me, and they imitate me every day,
Okay.
and I'm on medication.
Do you have a TPC caseworker?
When I leave today, I can call. Sometime today, I can call them. Her name.
Well, do you have a worker?
Who?
Do you have a caseworker with Texas Panhandle Centers? So will you do something for me? I'm gonna let you're gonna get out of jail today and sign a bond that tells you a date and time to come to my courthouse. So one, you have to tell me you'll come to the courthouse, most likely on Monday at 2. Are you itchy? Okay, so I'm gonna send a caseworker by to talk to you.
Oh, it started bad and it's worse. It's just you think it can't get worse, but it does.
Before you get out, okay?
Uh-oh.
Either that or do you want to see me tomorrow in jail when you feel a little bit better?
In jail? What do you mean in jail? You gonna let me go?
Well, I'm
to jail?
trying to get you out of jail, but you're having a hard time concentrating.
Sorry, I have special needs. You can't judge me. Why are you judging me? That's like,
Okay.
what do you understand? But if I'm paying
So
you.
I have
See, she's a judge and that's her job.
a question for you, Miss Lewis. If you sign a document today called a personal bond that gives you a court date to come to my courthouse, will you be here?
Tomorrow?
Well, Monday.
Monday, yes. Is it downtown at the Amarillo Police Station by Guy and Sanders? By the
Yes.
Sanders, before they closed the building?
Yes.
I just got out of jail and they brought me back. So
About 2 blocks from there.
yeah, because that's why I usually stay by with Guy and Sanders. But I'm
Okay, about 2 blocks from there. Okay. But today, hopefully, before you get out, I'm gonna see if I can't get a TPC caseworker to visit with you, okay?
I'm gonna make sure that he don't have people over there because I mean I went over there and he had Monica over there, but that's why I'm
Okay.
here.
Okay, so you're gonna go back to your pod and then they'll process you out of the jail. Be sure you're at my courthouse on Monday, okay?
Cool. Damn, shit, what's your
Miss Browning?
Juan Cantu.
Evening.
Hi, Mr. Cantu. I show you have a failure to display a driver's license and a no driver's license. Both are from 2018.
Yes, ma'am.
Okay, what has taken you so long to take care of these?
Because I believe it wasn't me. I believe a family member used my name and date of birth to get these citations issued to me.
When did you find out about them?
On Friday?
Oh, really?
Yes, because
Okay.
and the reason I do believe why I found out about them because I did apply for a job at the city of Amarillo a couple months back, and that's how they got my address here in the state of Pennsylvania. I am currently working with the state of Kansas to show proof that I had a valid driver's license issued through the state of Kansas during July and September of 2018.
One of these has a fingerprint on it, but the fingerprint ink is really, I don't know if they could get enough off of that.
That and then I wanted to look at the discovery, look at the citations, compare my signature to the signature on the citation because the individual.
Are you a fingerprint expert?
No,
A signature expert, whatever that's called?
no.
Handwriting
I don't do it, but the person that did it, that I believe was involved in it, is left-handed. I'm right-handed, and everybody has a unique, distinct signature exclusive to themselves. And that was just something I want to look at. Oh, go ahead. I'm sorry.
Did that person had they ever done that before?
From my understandings, no. But now that this has came out, I wouldn't be surprised because I know this individual also has multiple warrants for his arrest in Amarillo for the exact same violation.
Okay, hold on a minute. Miss Denholm or Christine, one of you can do a share screen. I'm since I'm on my laptop, I can't, I've got 2 different, I'm not in the place where I can share screen. Christine, pull up that citation on the failure to display a driver's license and go to the picture that's on there. This might be you, Mr. Cantu. Might be.
no,
It kind of looks, it honestly, it looks like
no,
you.
no,
And
and
sometimes people,
no, go ahead. I'm
sometimes people
sorry.
see it and go, and sometimes people see it and go, okay, that was me, you know, and sometimes people go, no, that was my uncle.
No, yeah,
So-
because me, and my dad, we share the same last name, and my brother, and I have photos of me and my family out at the
Uh-huh.
movies on the one that happened in July. And I have photos of Discord conversations and screenshots of my desktop with the timestamp of 7 a.m. on the date of in July. So I have screenshots. I have photos for the one in July, September. I can't find anything for. I did
Okay,
reach
hold
out
on a
to my.
minute. Hold on. Because you're telling me stuff. I'm sorry. I'm not really actually listening. Christine, can you pull up the screen share?
I'm not sure how to do that. Can you walk me
You're
through?
you're gonna go to where it says, let me find it. You're gonna go to where it says share. But first pull up the picture on your screen. Do you see
Yeah,
the
I have
picture?
that.
Okay, then go to share screen, or yours might look different from mine, but you can do share screen options.
I haven't seen this. I'm riveted, honestly.
You see them?
Under more, do you see share?
Judge, which document are you wanting to view?
On his
Take it.
on the failure to display driver's license,
Mm-hmm.
there's a photo
Okay.
of somebody who looks a lot like Mr. Cantu.
Okay. This on the Pennsylvania one, Judge?
I
think he's wearing the photo down below.
The citation.
For the
We want you
citation.
to if you'll look at his citation, there's a photo.
It might be on the other ticket.
I thought it was on the failure to display. Or is it on the let me go. I saw it. Yeah.
Oh yes, I see it, Judge.
Okay.
Let me blow that up a little bit. Can you see that?
I can. Mr. Cantu, who is that? Looks like you.
No, that's not me, but that's not who I thought it was.
Well, then who is it?
I am
That's
not
you.
sure. No, that's not me.
What's that hat say? Heather, can you see what the hat says? Does that say Abercrombie?
I can't tell for sure, Judge. It kind of blurs.
Oh, you know what?
What?
After looking at it, that is who I believe it is. Yeah.
It's you, isn't it?
No, it's my brother.
Who is it?
My brother.
What's your brother's name?
Corey Cantu.
Corey, Corey?
Yes, ma'am. Corey Cantu, Cantu.
Are y'all identical twins?
No, he was born 2 years after me. 1990, August 1st, 1990.
Well, Corey Evaristo?
Yep.
Where's he
Corey
stay?
Evaristo Cantu. Well, excuse me?
Where does he stay?
He lives in Amarillo.
Yeah, well, he's at Warrant. Okay.
Yeah, that's who I believed it was my brother. Now I have clarification of that. But
Okay. When are you coming to Amarillo, or are you here?
no, I live in the state of Pennsylvania.
Right. Well, you said you were applying for a job here.
Oh,
So
I did, but the job that they didn't I didn't even get interviewed or anything for the job from the city of Amarillo. So I quit looking a couple months back, and I just decided to stay where I'm at temporarily until I figure something else out. And I've been at my current job going on 2 years now.
were you living in Amarillo in 2018 when these tickets were issued?
No, I think I bought my first house in Kansas in 2018, 2019, but I was living in the state of Kansas.
Is there any way, and I know that's difficult, but is there any way you can prove that? Could you go back and get like an old paycheck stub or anything that would verify that you weren't here on those days?
Yeah, I can follow up with my previous employer. I don't know how long they keep check stubs. I was working for Tyson Foods during that time. I know I called them to see if I had time clocks or punches for those days. But they didn't have anything like that. But I can call them and see about pay stubs. And then and I'm getting that paperwork from the state of Kansas showing that I had a valid driver license through the state of Kansas during that time.
It's not whether you had a valid driver's license, it's whether you weren't here in Amarillo.
Yeah.
Okay,
No.
these warrants have been out there for a long time. So other than you trying to apply for this job in Amarillo, was there any other reason? I mean, these warrants haven't affected your ability to find a job other than trying to come here and get that job with the city.
Yeah. Yeah, no, I've been moving around. I've moved around to 3 different states since then. I've moved from Southwest Kansas out to Kansas City to Tennessee to Ohio to Pennsylvania. So I've moved around. This has never came up anywhere through my social.
So here's the bad news. I'm not going to lift your warrants, but if you come, do you come into town for any reason? Do you ever have a reason to come into town?
As of right now, no. I planned on a trip, but I wasn't sure when. Been planning to go see my dad.
As long as those warrants are there, I don't.
You could do a couple of different things. You could ask Tyson because this is July 16th of 2018 and September 19th of 2018. You could ask Tyson nicely and just go, hey, I really need to get these old records, showing I was at work on those 2 days in Kansas. And then submit that. We would make sure Miss Denholm sees that so she could then make decisions as to what she wanted to do. I will also send the failure to display. I'll send both of them to my warrant officer and ask her to do some research to see if she can verify that these were Corey. Definitely.
I don't believe him, but I'm also not sure. That's the straight read for me.
He was in town during those times because he's got those warrants. And she might be able to go, that is Corey. And if it is Corey, then Miss Denholm knows what action she'll need to take. If it wasn't Corey, then, if Corporal Dickey can't verify it was Corey, then that's a whole other issue.
No, and I completely agree with that. And I can see, especially being 8 years ago, super long time. I completely understand.
Yeah, those are kind of a pain. So I'm going to leave those warrants pending, but yeah, I want you to contact me again, contact me in, I don't know, 30 days.
Okay, no, that's fine.
Days?
And I'll reach out to my brother because I have his number and ask him, be like, hey.
But if he goes online and wants to just pay those tickets for you, he's going to go and try to pay them under your name.
Yes.
He's not going to help. He's got a warrant for him. He like all of a sudden he's, oh yeah, I'll go clear this up for my brother, who I screwed over by doing in the first place. Assuming that's the case. Come on.
I doubt he'll do it. He owes a bunch of money on tickets anyway.
No, and I saw that whenever I looked up the warrant list in Amarillo. He has quite a bit, and that it just didn't make sense to me because I knew I wasn't there. But I'll reach out to my brother to ask him, hey, I saw the photo. I know it was you, and see if he owns up to it and he admits it.
I mean, you got tickets in 2017 in a Hyundai, which is what they said you were driving.
Yeah.
I don't know. I see that. Was that in 2017? 2019, I mean. You got tickets in the Hyundai.
Which I don't know if this is normal, if you see this a lot where, hey, somebody's gave my name and my date of birth.
It's not the first, and sadly it happens with siblings.
Yeah.
Then you got tickets in the Hyundai in 2020. And more in 2020. Let me see. Oh yeah. Okay, we'll see what we can do, but again, the warrants will stay active. We're going to send it to the warrant officer, okay?
Okay. And then
Contact me in about 30, 45 days.
okay, contact you guys via email, or will it be another court appointment?
You might just set virtual court again. Just set virtual court and go, hey, just wanted to check status. But you also may have some information from Tyson at that point.
Yeah, Tyson, I'm working. Yeah, I'm trying to get as much information as I can. Like I said, I heard about it Friday and last Friday, and I was scrambling on Friday and yesterday, today, trying to figure out what I need to at least present. Hey, I know I wasn't there.
Like, do you have like another thing that sometimes when people are trying to establish like an alibi or something, you might have like a journal or calendar, like, I keep a bunch of stuff on my calendar or what I'm doing, like on my phone, which is all Google or Apple.
I had all that. I've never kept a journal or anything like that. Photos, I'm not too keen on photos. So there's not too many photos of me out there. That's why it's hard for me to prove anything along those lines. But
Okay.
I'm working. I'll give Tyson a call back to see if they have pay stubs from that time showing, hey.
I'm not into photos, and also I'm lying. Those two things make it difficult. Okay, I don't know. I really don't know if he is or isn't.
Hey, I had 40 hours that week or whatever. Didn't miss any time.
Timesheets, anything like that. That'd be great. If they won't cooperate with you, if they say you need to file what's called a subpoena ducis tecum, you can get on that same Texas law help that I told that guy earlier, and you can get the information from filing a subpoena ducis tecum, or you can get that information from to go to texaslawhelp.org and they can help you with that.
Yeah,
okay.
I was already trying to seek legal counsel as well, because I know this wasn't me, and I have no problems with the money. I'll pay the tickets, I'll pay whatever, but I just don't want it to affect my ability to drive and provide for my family. And I don't know if
neither one of these tickets will hurt you that way.
Okay.
No, they won't. But it's not fair that you pay him if it was your brother. So
yeah. No, yeah, and I don't want to do that. $500 combined. I looked at that. So $500, that's nothing to sneeze at. So
right. Okay, Mr. Cantu, you have a little homework to do. We're going to send it to our person here to do some homework, and you're free to go. Thank you.
All right. Thank you.
Thank you. And Ms. Denholm, you're certainly excused also.
Okay, we're here on 3 separate files. The first one is 071848FY. Second is 073185SM. And the third is 101549SM. All three are the people of the state of Michigan versus Brian Scott Cooley. And with that, may I have your appearance, please, Mr. Villard?
Good morning, Your Honor. Michael on behalf of the people.
Thank you. Mr. Cooley, state your name for the record.
Brian Scott Cooley.
And Mr. Cooley, we're here on your motions to set aside your convictions. And the court did receive the applications. I did receive the order on the application. And the court also received correspondence from the Attorney General's office. Mr. Villard, did you receive all that as well?
We only received Attorney General's office letter on the felony case.
the two domestic violence cases, we did not receive anything from the state's attorney general's office for those two cases.
Well, it is the same letter. It's dated August 29. It does have the heading for all three files. Is that what you received as well, Mr. Miller?
I do have that.
Okay, so I do believe it addresses all three files. The body of it really only does address the possession of marijuana. However, the caption does address all three files. So, Mr. Cooley, you may proceed with your motion to set aside your conviction, sir.
What do you say?
Oh, hold on, Mr. Cooley. Before we begin, I'm going to have you raise your right arm. You swear or affirm to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Okay, you can put your arm down. Now, what do you want me to be aware of?
What do you mean?
Aware of what? What's that?
This is your motion. What do you want me to be aware of? What do you want to tell the court?
Proceed, big dummy.
Expungements.
That I just want my expungements.
Why do you think that you're entitled to an expungement?
I don't know. Those things have changed. Different than what it was now. It's been over 12 years.
Is that it?
Is it okay if I speak with Brian? I'm his wife, and I was the victim in the two domestic violences.
No, I'm addressing
Lord.
Brian, so he could have an attorney talk on his behalf if he wants.
Okay.
Exciting and new.
But you're not his attorney. You'd be the victim. So, Brian, if there's anything else you want me to be aware of, that would be the time to tell me before I make a decision whether or not to grant your request or not.
It would be nice to have these things erased off of my record just so I could apply for jobs and not have to be questioned about these things that I've done in my past that I've not done.
Yes, we're aware of the benefits of expungement. What you need to do is set forth the reason why you deserve it. Oh my God.
In a long time or been in any trouble. I haven't even had a speeding ticket. I mean, I don't think I deserve to have these on my record no longer.
So you don't deserve to have it on your record. Anything else?
That's all I have to say.
Okay, Mr. Millard.
Well, Your Honor, I think it's the marijuana charge. I think we have limited discretion to argue about that. In terms of the domestic violence, I think that Mr. Cooley probably would have benefited from having an attorney come in and state his case for him. He has an aggravated domestic violence in 2007 and another domestic violence in 2010. And he didn't choose to take the time to say to the court why he has addressed those issues and anger management issues and what other issues he's had to address. Obviously, he's had, since 2010, no further incidents. He's still apparently with his wife, who was the victim in this case. So I think that probably speaks highly for him. However, I don't think that he has really demonstrated to the court that he has taken it seriously enough to at least inform the court of what steps he's taken to address any kind of anger management issues, other than he's still with his wife, which I think is commendable. So I think he would have benefited from having an attorney speak for him.
Yes. Well, quite honestly, Mr. Cooley, I agree with Mr. Millard. You're here on 3 separate files for 3 separate convictions. The marijuana case the court has no problem setting that aside. I think that should be set aside, and I will follow through with all the paperwork in that regard. In reference to 073185SM and 101549SM, one is for an aggravated domestic violence, and the other is for a regular domestic violence. The court inquired of you, said, what do you want me to be aware of? And it was just kind of a scoff and saying, well, I haven't even got a speeding ticket, so I deserve to have my record clean. And there's more to it than just not getting in trouble. It's whether or not the individual, the circumstances and behavior of the applicant from the date of the conviction to the filing of the application weren't setting aside the conviction, and it would be consistent with public welfare. So the court really needs to look to see what happened back in 07 and 2010 and what's changed from then to now. Hold on, sir. A lot of the time people talk about getting into therapy, doing counseling, working through anger management, attending a domestic violence class, having applied for jobs, having this be a barrier to their employment. So unfortunately, you didn't really give me a whole lot to work off of here. And I did allow you opportunities here. What I'm going to do here is, typically with a denial, it's a 3-year wait. I'm not going to make you wait 3 years to try to apply again. What I'll do is I will give you earlier than 3 years after the date of this order, but no sooner than you think that within the next 8 months you would be able to get involved in some sort of programming and be able to provide proof of that. If I were to set this for, you could apply again in 8 months, do you think that you could do some things to show the court what has changed from your personal standpoint to the present, or would that not be enough time for you?
I think that would be enough time.
Okay. So going through all of these, because we have 3 separate files, sir, in file 071848FY, that is a felony case, the controlled substance possession of marijuana. The court will find that the applicant has not been convicted of more than 3 felonies. You have not had any convictions for assaultive crime set aside, correct?
No.
You have no pending charges?
Nope.
Supervisor, what was this original charge? Was it the controlled substance possession? That was just down to a 93-day? Was that the plea?
That is my understanding.
Okay. Okay, so Mr. Cooley, I have gone ahead and signed the order on the application to set aside conviction in reference to the possession of marijuana. Now, just so you know, under MCL 780.623, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in each case to which this order applies. If the conviction is for an offense that is reportable to the Secretary of State in accordance with MCL 257.732(22), the driving record shall not be expunged. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. In reference to 073185 SM, the court will make the following findings: that the Michigan State Police has reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. The applicant has not had any convictions for an assault of crime set aside under MCL 780.621 during their lifetime. There are not any criminal charges pending. The applicant has not been convicted of any criminal offense during the applicable time period. The applicant is not requesting a felony be set aside, so that's not applicable. You're not asking for an OWI. Time period has passed. An opportunity has been given to the AG and prosecuting official to contest the application. The court has not found the circumstances and behavior of the applicant from the date of the conviction to the filing of the application warrant, say aside the conviction, I have not found that it's consistent with public welfare because I just don't know right now. I am going to find that it's denied. And I'm going to give you 8 months to work on that. So 8 months from today would be October 19, 2026. And I'm going to make the exact same findings in reference to file 101549 SM. That is the charge of domestic violence. Not been convicted of more than 3 felonies and had no convictions for assault of crime set aside, no pending charges, has not had any convictions during the applicable time period. And your Ezra. Bless you.
Thank you.
And again, I cannot make the finding that the circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application warrant setting aside the conviction, and it is not consistent with public welfare. I can't make that finding today because I just don't know. October 19, 2026 is the first time that you can reapply. You understand that, Mr. Cooley?
I think I'm starting to understand it now.
Okay. Yeah, just because, the time has gone and you haven't gotten any trouble, you have to make a showing that it's in the public's best interest and that you've done something different from then to now.
Yeah, I didn't understand that until now. That I had to give a speech on how everything's changed from then to now.
Well, obviously something happened back then. You had the
right. Being a teen,
want to see how
having kids at a young age, and yeah, it's definitely hard.
Okay. Well, we'll see back here in about 8 months?
October 19th.
Okay, thank you, Mr. Cooley.
He's got to do the change.
And you will need to resubmit all your paperwork. You understand that?
Oh, yeah.
Okay, very good. Thank you.
Thank you.
Okay.
I don't know. He wasn't the worst, but after seeing that attitude, I'd be more inclined to just be like, you know, I'm just going to deny it. When
Are we okay to hang up?
You're all set. Yes, thank you.
Thank you.
Oh. 14 that the District Court for the County of Washington, State of Michigan is now back in session. The Honorable Judge James.
You may be seated. Court does call the case. Clara Gahan versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison, due to Michigan Court Rule 8.120 under the supervision of Attorney David Santacruz.
Permission to practice is granted.
Thank you.
No.
No, she is unrepresented. She is not.
Yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
If you want to hear the motion, Your Honor, I'm willing to argue it.
I'll hear the motion, but what would you like the court to do? I don't have the other side here.
Yeah, we could go forward with the motion.
All right, go ahead.
I mean, he's not stupid, but that's the only thing he knows. He's like, I've got a motion. I prepared that. I'm not a seasoned attorney. I've got one button to press. If you ask me, Judge, I'm going to proceed on my motion.
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025. And the relevant terms of that, the conditional order of dismissal was that my client, Ms. Ellison, was to vacate the property by the end of the year and also facilitates funding for Ms. Gannon. And then in return, Ms. Gannon was supposed to return Ms. Ellison's security deposit within 30 days of vacating the premises as required by law. So Ms. Ellison vacated the property. That's my client vacated the property on December 5th, 2025. And that 30-day period for plaintiff to return the security deposit was ended on January 4, 2026. And we had not received the security deposit.
Oh, he's a little newbie. He's nervous as hell. I feel bad for him.
By that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes.
Did your client supply notice? Or
yes, Your Honor. Yes.
A forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that, I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act having been waived if you are placing it in the confines of a conditional order of dismissal?
No, Your Honor. The conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. Let's see. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, the under MCL 554613, plaintiff is liable to my client, Ms. Ellison, for double the amount of her security deposit retained. And Ms. Ellison,
when was the security deposit returned?
It was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February. But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned. And so this caused great hardship to her, a fallout with her new landlord, and potential, more litigation. And she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct. And Miss Ellison contends that she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that, I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Ms. Gannon failed to abide by the law. And so Ms. Ellison contends that she is entitled under the statute, and that's the statute. The purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of the landlord, but and the landlord not following through. And I would just say one more thing is that counsel or myself tried to reach out to Ms. Gannon many times. When it came to our part, our obligations under the conditional order dismissal, Ms. Gannon was very, very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Ms. Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And oh
my God, this is so painful. He's doing great. In substance, he is fine on everything, but he's just nervous. And this is how you do it. You get better at things with repetition. But it's painful to sit through this. He will be an excellent attorney. He's already good. He just sounds nervous.
Client, Ms. Ellison, requested this court reopens the case because it was previously closed under the conditional order of dismissal and then awarded.
Why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act were, because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order of dismissal circumvents the Security Deposit Act.
Okay, now the judge is just screwing with him in a good way. He's actually kind of playing law professor here, low key. He already knows what his ruling is. He's like literally trying to give the kid an experience. That's what's going on. It's cute.
No, I don't think so, Your Honor. I think
Well, I know you don't think so, but wouldn't you have to reserve it?
Well,
I mean, give me a reason why you wouldn't have to reserve your rights under the security deposit. You're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. And also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute.
But
by the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the remedy provision that's contained in the statute.
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, the law is the law, and if we gave more.
No, the law is the law, and the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said. But it's not said.
Understood, Your Honor. My client left at a timely manner. I mean, the fact if this might be a different case if my client left the place a mess and and there was
but it wouldn't matter. But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing. But regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisions. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order dismissal would force her to return the security deposit, even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall.
All right, Ike, you're doing fine here, buddy, but you've made you've missed two critical things. You can't show up in front of Judge Simpson representing a landlord, number one. But if you do, for the love of God, at least be a cute female.
return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have. Because you already altered it with the 3 days versus 4 days. You already.
Oh, he is representing the tenant? It was so boring. I did. Okay, now Judge Simpson's totally playing. He doesn't care. This is just devil's advocate law school. That's it.
Altered it, making it mandatory to return it, irrespective of anything else. There's no exception here. There's nothing. There's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you.
Beautiful. Beautiful. This, by the way, this is universal. I made a little joke at Judge Simpson's expense, but this impulse is universal in law. People can't help it. It's a conspiracy of all attorneys that you will get this. He's went out of his way to give him an argument and things to think about. This issue's small. It doesn't matter. He just wants him to be christened in actually getting an argument. And it's not like a big thing, or the outcome doesn't matter much to anybody. But that's what's going on here.
That's all I had on it.
Yes.
Right now. HP foreclosure solutions versus all occupant.
Good afternoon to you and your staff, Judge Simpson. Attorney Paul Spaniello, P72366 on behalf of the plaintiff.
Any occupants?
I'm here. I'm sorry. I'm trying to unmute sorry, Mary Cheatham.
Okay, gotcha.
If Lauren Brown would have come into court, rolled into court with that same argument, the judge would have made two side jokes not related to the argument whatsoever, and then ruled in 20 seconds, and we all would have moved on. That was pure theater.
All right, this is a termination. This is a motion.
This is Freedom's motion to set aside a default, Judge, for what it's worth.
Did you get a copy of it, counsel?
I had to ask the court clerk, and they were gracious enough to email me a copy. Yes, I did.
All right, very good.
Thank you for asking.
Ma'am, what is your position on why I should set aside this termination?
I did not see the court document to come to what am I saying? Okay, so I did not receive in the mail the court date until 3 days after the court date.
Okay, let me explain a couple things.
Okay.
There are two parts to that you would have to show this court.
Okay.
For the court to set this aside.
Okay.
The first part of it being that you'd have to show good cause for your failure to appear, which I think you were going to get into. Okay. What I think is more problematic, I think, for you is you have to show this court that there's a meritorious defense to the claim of the termination.
Okay. So I had entered into a lease with them. There was some problems with the payment. I think I addressed that in my motion. I have been in contact a little bit with, I believe her name is Michelle from HP. And I believe that we could possibly come to an agreement to allow me to just extend my stay a little bit so that I can get everything out of here. I guess.
Who did you lease from?
HP foreclosures.
Is that right, counsel?
Your Honor, during the course of the suit, and I do have Ms. Shifter here if you'd like to take testimony, but Ms. Shifter attempted to work out a resolution with Ms. Cheatham to keep her in the property. There was an agreement that if a security deposit was tendered in first month's rent, that they would have this binding lease and that we would ultimately dismiss the case. As you'll see in Ms. Cheatham's unsworn narrative, I guess her money, her husband or spouse absconded with the money, so nothing came of it. My client had attempted to reach out to her on occasions and was largely ignored, and we proceeded. So, effectively, there is no lease, albeit, we tried to work something out with her, but this if I could finish.
Sorry.
This case was filed on December 9th. The redemption, I don't have it in front of me, expired late last year. And now we're here on February 20th, Your Honor. And there's still been no monies produced. So it's our opinion that there is no lease agreement. I mean, my client would not enter into a lease without that.
But I guess, was there signed documents of a lease?
It's my understanding my client did sign the lease, but predicated that the effectiveness of the lease on that payment.
Okay. So I don't have a copy of the lease.
Well, it wasn't a part of this action. It was something that occurred, my understanding, during the course of this matter. When I appeared at the first hearing, I was hopeful, and I even may have put it on the record that the parties.
Counsel, here's the problem with that argument. Under paragraph 5F, this action was maintained because of the expiration of the redemption period, but then specifically indicates no tenancy.
Correct. And there was none at the time that the matter was filed, Judge. I'm sure Ms. Cheatham will tell you, and my client representative will tell you, that after this was filed, they were trying to work out a resolution to keep Ms. Cheatham in the.
But then we get into the other issue. So you're saying this signed document, this lease, was entered into after this case was filed?
That's my understanding. Yes, Judge.
Ma'am, is that correct, Ms. Cheatham?
Yes, if they filed it on December 9th, because I don't.
When did you sign the lease?
I did, sir. I did, Your Honor.
No,
and I am
when?
prepared.
When?
It was in January. I don't know the exact date. Might have been like the 9th or something. I'm not quite sure. But I am prepared to. I have the money to pay them at least the $3,800.
Hold on. Stop.
Okay.
So after this action, both parties signed a document purporting to be a lease. I don't know how there is a conditional lease, but I guess that's what counsel is saying. And Ms. Cheatham is saying that there's a lease. I don't think, counsel, you can argue that there's no lease if both parties sign this document. I don't know how that works.
Well, if I may, just for purpose of nothing else, Your Honor, making a record, there's no consideration. I mean, my client could sign a lease, and if it's predicated, it's our position, it's predicated on payment, like most leases are. And if no security deposit was tendered, no first months, effectively there's no lease.
No, that's not how tenancy works. I mean, if she's in the premises, you're in the premises, ma'am?
I am, Your Honor.
she'd been in the premises during the whole redemption period, my
I
understanding.
have not. I was in a halfway house. I just got released on January 30th.
Well, we were here before your January 3rd. We were here on January 9th. Your Honor, it was the first hearing, I believe.
Because I'm the executor of the will, so I've been like appearing for court hearings and things like that. But I've been pretty upfront about that. Like when I first came into contact with HP Foreclosure Solutions, that I had just been released from incarceration last July, and I've been in the halfway house since.
Okay,
since
so
then
who's
until-
going to send me a copy of this lease or this conditional lease or this thing that one side is purporting not to be a lease, but the other side is saying it's a lease? Because I don't even know how I begin to rule on this without a copy of it.
I don't have a copy. Ms. Cheatham or my client's representative, Ms. Shifter, I could have Ms. Shifter send me a copy and I could forward it to the court via email, or Ms. Cheatham, I guess, could. I don't have a copy.
If I may, I'm sending that right now.
Okay.
Michelle Shifter.
I'm sorry, Your Honor.
Let me pass this matter.
Okay, thank you. And
Then it
then,
needs to be sent to my staff.
may I have the staff, can somebody put the staff's email in the chat if they don't mind?
She is putting it in there now.
I appreciate it.
Court recalls HP foreclosures versus all occupants.
Paul Spaniolo, Your Honor, on behalf of the plaintiff.
Mary Cheatham.
Counsel, how are you? I don't know how I get to the point of you saying when I'm looking at this that this is not a lease. Parties have all signed this, right?
Correct, Judge. As what was sent to me, I reviewed it in anticipation of us going back on the record. It does appear that it's signed. Other than the consideration provided by Ms. Cheatham, before you.
Yeah, the problem I've got here is that I don't think, quite frankly, that, well, I'll just say it this way, that defendant has a valid lease. And I would submit to you that in the beginning of this case, because of that, this court doesn't have jurisdiction to hear this case. I won't have subject matter jurisdiction under the theory on which this case has been filed. Because you filed it because of the expiration of the redemption period, but at some point a new lease entered in or new interest in property entered in, which I can see. So I don't think, there may be other reasons or basis upon which this case could then proceed, but I can't proceed as is. I don't think the court has subject matter jurisdiction. When I don't have subject matter jurisdiction over the case, then the only thing I can do is dismiss it.
I anticipated that, Judge Simpson, and I appreciate that. Would you just be inclined to dismiss it without prejudice, and we'll send out the appropriate notices today and get the ball rolling on an appropriate matter before you.
All right, very good. So, Lexa, that dismissal is without prejudice.
And respectfully, thank you for entertaining my argument. I appreciate it.
Oh, sweet Jesus. That appropriate action is going to be a termination of tenancy. I thought he'd get out of there, but no, it's going to be back in front of Simpson. So 7 years from now, they'll get her out, and then maybe they can get back on the foreclosure at that point.
Not a problem, sir. All right.
Take care,
Thank you.
you and the staff. Have a great weekend.
You do the same. You also, Ms. Cheatham.
Thank you, Your Honor. You have a good day.
All right, and then we're on the record in the matter of the state of Michigan was Lauren Tidwell, 26159.
I just caught up to the fact that Biggin isn't streaming, so I got more clips.
Good morning, Your Honor. Dennis Whitey, P79560, on behalf of Ms. Tidwell, who appears by way of Zoom. Ms. Tidwell, please unmute and state your full name for the record.
Andrew also sent me one.
Lauren Tidwell.
Okay, good morning to you both. Today is the date scheduled for the probable cause conference in this matter. And counsel?
Your Honor, my client wishes to exercise her right to a preliminary examination. I heard you given next week as the date in the afternoon, and that'd be perfect if that's still available.
All right, February 26th at 2 p.m. All right, witness and exhibit list by February 23rd. Okay, sir, I need you to keep your volume down if you have to talk to the court officer because you're interrupting the record. Bond and conditions will continue. Thank you.
Judge, may I adjust the bond with regard to the tethers?
Yes, currently the bond in this matter was $20,000, 10%, with the following bond conditions. No contact with Ms. Pearson, not to return to the Auburn Taverna or Ms. Pearson's place of address or any other bars, not to possess or consume any alcohol or drugs unless prescribed, not to possess or have access to any firearms or weapons, and GPS and alcohol tether. Okay? And counsel?
Yes, Judge. We just want to address the tethers. She currently has 2 tethers on her, one for alcohol, one for GPS. Ms. Tidwell does live alone at her home. The domestic count does not result in the parties living together. Ms. Pearson lives separate, and Ms. Tidwell is still at home.
Like a woman with 2 tethers. That way you know where she is.
She's gainfully employed through the University of Michigan. She has great ties to the E-Course community as well as River Rouge and Wyandotte, but was born.
Yeah, she has great ties to the community. She's double tethered.
Born and raised in E-Course, well-known name and family within that community. She's not a flight risk. She's not going anywhere. So we'd ask that you remove the GPS tether for that reason. She has had no contact with the complaining witness in this case or the locations as the court just described. In addition, I did advise her, though, if the alcohol tether was removed, that she would probably have to do random testing, knowing Your Honor's propensities in these type of cases, and we understand. So we'd ask that those tethers be removed.
Okay, well, counsel, the court wants to ensure the safety of the victim in this matter as well, which is one of the reasons why this court ordered the GPS tether. And if I recall correctly, there was a significant amount of alcohol involved on this date, which is why the court ordered the alcohol tether as well. Let me see. Because it's alleged that your client had a very high level of 0.191. So what I'll do, counsel, is I will amend the alcohol tether to be random testing, but I'm keeping the GPS tether.
Okay, Judge, if I could, given that, Ms. Tidwell, the judge is going to keep the one tether on. Do you want to just keep both of them on so you don't have to randomly test?
Yeah, I'll just keep them both on.
Okay.
No. You requested that it be removed. And you wanted to address the tether. This isn't a negotiation or, I'd rather just do it this way. I granted the motion to remove the alcohol tether. Your client can participate in random testing.
Judge, I understand that, but there was 2 tethers on here. And if she has the one tether that remains, the same issues arise. So she might as well just be monitored that way instead of trying to do random testing. I'm not trying to negotiate. I was just given the court's order. It might be just easier because you're leaving the one tether on just to have the second tether as well. That's all.
The court's going to amend the alcohol tether to be random testing. You can have the alcohol tether removed. Email into probation, they'll give you information about amending that, removing the alcohol tether and having the random testing.
Okay. And
thank you. Have a good day.
Thank you. See you next week.
All right. Bye-bye. So let's go on the record in the matter of the state of Michigan versus Luke Durant, 26161.
Good morning, Your Honor. David Cripps, P34972, appearing on behalf of Luke Durant, who's joined us by Zoom.
All right. Good morning. And today, and sir, your name for the record, Mr. Durant.
Luke Anthony Durant.
Okay. So, counsel, before I begin anything here, it's my understanding, so we have to address the bond for your client because your client had a surety company post a bond for him. And then apparently that surety company took your client into custody and dropped him off at the Wyandotte Police Department. So I don't know if there's currently a bond posted for your client, and if the surety company has revoked their bond, although they haven't filed the motion here with the court, then your client either has to go back into custody or post the 10,000 10% bond this court ordered. Are you aware of all that, counsel?
No, Judge, that's all news to me. I thought he had went through a bail bonds person and posted bond.
He did. He did. So your client didn't tell you anything that just happened this week on Monday? Mr. Durant?
Yes, Your Honor.
Did you discuss all that with your attorney?
I wasn't quite sure what was going on with it either, because the person that posted the bond for me was a friend, and I haven't been talking to her since I've been here because I haven't been talking to anybody.
Pause. Mr. Cripps, I'm going to put you in a breakout room with your client so the two of you can discuss that, because we're going to have to address the bond to make sure it's getting it's appropriately posted.
Yeah, Judge, could you set a personal bond for him now? I think we're going to resolve this case at the next probable cause conference.
I've already set a bond. I need to make sure.
I said to slip into something more comfortable here. Oh, yes.
That the bond is still valid. That was posted by the surety company. But I also want for you to speak to your client so you can hear from him what he's going to tell you.
Yes, Your
So
Honor.
we're going to put the two of you back into a breakout room.
Thank you.
Thank you. Let's go on the record. Let's go on the record. The matter of the state of Michigan is Raymond. Hello, Ramon? Ramon. Who would do that to you? Ramon Ray Raymond?
My parents.
On purpose? Or they just couldn't think of a name? Okay, well, okay. So, counsel, your appearance, please.
John Goldcorp, P30758 on behalf of Raymond.
Okay. Sorry, I said that not out of disrespect to your parents, but I'm sure I'm not the first person that's asked you.
No, you're not.
Okay, insert your name for the record, please.
Raymond.
Okay. And so today is the date scheduled for the arraignment pretrial finally, because your client continues to fail to appear. So thank you for showing up. So counsel, as to the arraignment.
As to the arraignment, Your Honor, stand you to the charge, waiver form reading of those charges, ask for the plea of not guilty be entered.
All right, the court will waive the formal reading and for plea of not guilty for purpose of the arraignment and as to the pretrial, counsel.
As to the pretrial, Your Honor, I've had an opportunity to discuss this matter with the prosecutor. It's my understanding that in return for a plea of guilty to operating while intoxicated, first offense, the more serious charges of operating intoxicated, second offense, as well as the high BAC would be dismissed. I've discussed with Mr. Raymond's constitutional rights. He understands those constitutional rights, and understands that by entering into this plea agreement, he would be, he would be waiving some of those rights. I've also explained to him any sanctions upon his driving privileges set forth by the Secretary of State. He understands those as well. With all of that said, Your Honor, he wishes to avail himself of this plea opportunity. There are no immigration issues.
Okay, so sir, I'm going to have you please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Did you pick them up? A little bit louder, please.
Yes.
Okay. Sir, you heard the plea that was placed on the record, correct?
Yes.
As to the amended charge of operating while intoxicated first offense, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
Yes, ma'am.
You also understand, sir, that by entering into a plea, you'll be waiving some of those rights.
Yes, ma'am.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
All right, counsel, if you can please forward your client.
Thank you. Mr. Raymond, on June 28th of 2024, were you operating a motor vehicle in the city of Wyandotte? Yes, sir. And prior to that operating of that motor vehicle, had you consumed any alcoholic beverages? Yes, sir. And were you, what did you consume? Beers. And how many beers did you have, sir? Honestly, I had it before. I'm about fishing. I was just enjoying. So in other words, quite a few. Yes, quite. And you were out fishing, and then the hot sun got to you, and instead of calling an Uber or your wife to come pick you up, you got into a car. Is that correct? Yes, sir. You came in contact with the Wyandotte Police Department. Is that correct? Yes, sir. And when you had contact with them, they gave you certain field sobriety tests. Is that correct? Yes, sir. You submitted to what they call a preliminary breath test, and you were arrested. Is that correct? Yes, sir. And at the station, you took a blood test. Is that right? Or, I'm sorry.
Breath test.
Breath test. And are you aware that the results of those breath tests were 0.19 and 0.20? Yes, sir. That's a satisfied, right?
All right, the court is also satisfied, although that's the first time I've heard the son as a defense, but.
Well, I was using that not as a defense, but as a
contributing factor.
Determining factor in making a bad decision.
Yes. Okay, the son didn't do it. Okay, all right. The court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge, dismiss the original charge per the plea agreement. And as to bond counsel.
As to bond, Your Honor, I know that he failed to appear on other occasions. We're asking that the bond be reinstated. He did show up today. He's been quite cooperative. We're asking, and he's accepted responsibility.
Yes, he showed up today because the surety bond company posted it for him. Perhaps they would go find him like they found Mr. Durant.
Well, then as to bond, Your Honor, we'd ask the bond be continued.
Okay, so Mr. Raymond, why didn't you want to come visit us?
I was out of town working.
All the times that you were supposed to?
Yeah, I was in Wisconsin working, and I was trying to make it back, and I didn't make it back in time.
Okay, do you work in Wisconsin currently?
No.
No.
No, I'm back here working now.
Okay, where do you work, sir?
I work for myself on the landscaping business.
You couldn't find any lawns to landscape in Michigan? You had to go to Wisconsin?
No, I was working for my cousin.
Oh, okay. Okay. If you were to test right now, sir, what's in your system?
Yeah.
Do you have a valid prescription for that?
It's I got that part. I'm waiting for it to come. I had it renewed.
When did you renew it?
2-3 days ago. I'm literally waiting for it to come.
Okay. And how long did you have it prior to that?
About 34 years.
And is the medical reason from a treating physician or a medical marijuana clinic doctor?
From the doctor.
From your doctor?
Yeah.
Your treating physician? Somebody that you see on a regular basis?
Yes.
Okay, very good. Okay, the court's going to order your bond to continue. You're not to possess or consume any alcohol or drugs unless prescribed. So just make sure you get a copy of that card or letter from your doctor to the court.
All right.
Okay, stop over at probation and you'll get all of your next steps as well as a copy of your bond condition.
Okay, thanks.
Okay, oh, I'm sorry, just one moment. It's not lost in this court that you had a prior just a couple of years ago. The court's going to order you to participate in random testing.
Okay, thank you, Your Honor.
Thank you. You'll get all that information as well. Okay, great. All right. Okay, and so this one is, oh no, this one is this one. No. All right, let's go off the record for a moment. Mr. Cripps, did you already speak to your client regarding the bond issue? Mr. Mohammed, were you made aware of the bond issue regarding Mr. Durant?
No.
You can tell because you're like, oh, what's that? Okay.
Yes, I did, Your Honor.
Okay.
I think I understand it now, Judge.
Okay.
Not this time. See.
Okay.
Okay, so counsel, I know that we're ready to go on the exam. I'm just going to do this one adjournment with Mr. Cripps. We're on the record in the matter of the state of Michigan versus Luke Durant, 26161. And appearance for the defendant counsel.
Morning, Your Honor. David Cripps, P34972, appearing on behalf of Mr. Durant.
Mr. Durant, your name for the record, please.
Luke Anthony Durant.
Okay. So, counsel, I see that you're asking for an adjournment because you were just retained in this matter. The court did receive your appearance. The court will allow the adjournment in this matter.
Thank you. I think we'll have a result by the next court date. Thank you very much, Your Honor.
We'll set this for March 5th
Thank you.
at 10:30 a.m. All right, so Mr. Mohammed, this is where I'm going to ask you to maybe for some input. But here's the information I have regarding your client's bond. And I bring this up because I need to make sure that my order is being complied with. This court ordered a $10,000 10% cash surety bond on February 6th. It appears as though February 9th, well, there's also bond conditions. It appears February 9th, there was a surety posted by A1 Bail Bonds on behalf of your client. Tuesday morning, I was informed that your client was in Wyandotte Police Department custody because the bail bonds company was revoking, and I have that in quotation marks because the court can revoke a bond, not a surety company, your client's bond. It appears, I have not had that issue occur, so I did a little bit of research on it, and it appears as though the bail bonds company would have to file a motion with the court here to be released from the surety that it posted on behalf of your client. I am unaware as to whether or not your client's bond that was posted by the surety company is still in effect or not. I have not been given that information. I bring that to your attention because if that bond is not currently valid, then your client has to post 10,000 10% bond or turn himself back into custody with the Wayne County Jail. It would also appear as though the bond company took your client to the wrong police station because they picked him up from the county jail. That's where the bond was posted. That's probably where they should have dropped him back off. So Wyandotte PD chose to release your client. So, sir, good thing you showed up today. But counsel, that's where we're at with the bond. So, Mr. Cripps, do you know what this current status of your client's bail bond is, surety bond is?
I have no further information other than what you stated on the record, Judge.
Okay. Mr. Durant, what information do you have?
So the girl that put up the money, I haven't been talking to her since I've been released.
Sir, let me say this. I don't want a backstory.
Okay.
I just want to know, excuse me.
$500 to have my bond revoked because I'm not talking to her.
Okay, Judge, so what a third party, I think I can explain this. A third party on behalf of Mr. Durant posted bond. So there was a falling out between a third party and Mr. Durant, and she must have contacted the A1 surety bonds. And from that point onward, I think you put the record together as to what occurred. I'm asking the court to consider a personal bond on his behalf because I think we'll have this case resolved at the next court date. At the probable cause conference on the 5th.
Mr. Mohammed, I know all this is all new to you and quite convoluted, but I don't know if you have any input as to bond or otherwise.
So Judge, I have a question.
I think he screwed up a cock job. That's just my theory. I'm not sure. I wasn't there.
The finance department or team filed a motion with the court because
The finance team?
Was it the bail bond?
Bail bonds? No, they have not filed the motion. And I don't even know if what they did was the proper procedure or not. My research shows that there should have been a motion filed, but I don't know if that's accurate or not.
So if the law requires that a motion be filed and there's been no motion filed, I don't see how it would be revoked by them sending an email, or I don't know how they delivered it to the court. So I don't think there's a change in circumstances as far as amending the bond at this time. I don't think we need to switch to a personal. I don't think anything needs to be done until and if a motion is filed with the court.
Well, here's the concern, and I would agree with you, counsel. However, here's the concern that this court has is that there was they dropped off the defendant, and they included in that well, then they sent an email and for these reasons, we are respectfully requesting to be released from the bond at this time. I've attached proof of incarceration and bond discharge form. So that is why I'm asking these questions, because I don't know what the status of A1 bonds is. So counsel, I need for one of two things to happen. Either your client has A1 bail bonds, contact the court, letting them know that the bond is still valid, or your client has to post a bond or turn himself into Wayne County Jail. All this has to occur by the end of the business day today.
Yes, Your Honor.
And then also you can all be assured as well that there will be a hearing initiated by this court with the bail bonds company because the procedure was not followed.
Yeah.
So that is what this court's going to order. So counsel, by 4 p.m., I need to have information, proof one way or the other, whether the bond is still valid from A1 bail bonds company, because again, we don't even have any information from Wayne County Jail yet that the bond was posted. The only reason we even know this is because the bail bonds company dropped Mr. Durant off to Wyandotte Police Department. So Wayne County Jail has yet to get anything to this court, even though it's been 10 days since the surety bond was posted. So we don't have any information regarding that. Clearly bond was posted because Wayne County Jail released your client, and there was a copy of it provided by the bail bonds company when they dropped Mr. Durant back off to the Wyandotte PD. And so this court needs.
With the paperwork.
Mr. Durant,
Yes,
you're
sorry.
speaking is interrupting the record.
I'm sorry.
So one of three things has to occur. There needs to be confirmation that A1 bail bonds is still holding the bond and ensuring your client's presence. Your client has to post the $1,000, or your client has to turn himself into Wayne County Jail. One of those three things has to occur by 4 o'clock with proof submitted by counsel.
Judge, I'm going to be in a lengthy hearing probably till about 4 o'clock today in Taylor District Court. So I won't be able to do that. I advise my client what he needs to do.
Well, I need to have, even if it's proof sent in by your office counsel, but I need that by 4 o'clock today.
Okay. Well, I'll advise Mr. Durant what to do then. And I'll check in as soon as I'm done with my hearing at 4 o'clock, Your Honor.
Okay, thank you. We'll still be here. We'll be in a jury selection.
Thank you, Judge.
I have a question.
Oh, just one moment, counsel. Yes, Mr. Mohammed.
If there was a resolution today, would that still be an issue as far as the bond?
Well, it is, because this court's order is not being followed potentially. So I need to know that. And I need to know by which party is it not being followed. It could very well be from a third party and not Mr. Durant. I'm not suggesting that Mr. Durant did anything improper, right? But in any event, I need to resolve the issue as to what occurred, whether or not the law was followed by the bail bonds company, and number one, and number three, to make sure that this court's order is being followed as far as the bond that this court set.
Court.
Okay? Mr. Durant, if you were to test right now, what is in your system?
Nothing, Your Honor.
Mr. Cripps, are you available next Thursday for a hearing with the bond company? You're muted, counsel.
I could do it by Zoom, Your Honor.
Well, no, I need in person because the bond company has to be in person. Are you able to do it in the afternoon in person, counsel?
Let me check my schedule, please.
Okay.
I know we set that to March 5th, coming in for the probable cause.
We did. I'm not looking to go out 2 weeks for this hearing with the bond company.
Would that be in the afternoon on the 26th, Your Honor?
We could do it in the afternoon on the 26th.
I can do it in the afternoon.
Okay. What time works for us?
What time, Your Honor?
1:30 p.m.
Thank you.
Okay, thank you very much.
Thank you, Judge. Have a good day.
All right, thank you.
Are you Riley Bannon?
Yes, sir.
This is State of Kansas versus Riley Bannon, case number 23 TR 2850. Counsel would state their appearances, please.
Jeremy McGee on behalf of the state.
And you are Riley Bannon?
Yes, sir.
All right.
All right. For those of you keeping score at home, that last one was Zach's fault, and this is Andrea's fault. I have not seen it.
Mr. Bannon, the notes that I have reflected you were in court on February the 6th, and you indicated you would be representing yourself. Is that still how you wish to proceed?
Yes.
Okay. Are you requesting this trial, that this matter be set for trial? How is it you're planning to proceed?
I was just trying to be honest as possible with you guys, and hopefully I'd be able to get a bond today. I'm pretty ignorant.
Well, okay. When you say pretty ignorant, that's a good sign that maybe you should have apply for an attorney that could assist you in these matters.
Okay.
All right. Well, okay.
I'm filled with confidence. Oh my God.
You were supposed to be in court, according to the court file here, on November the 29th of 23. You
Yes.
failed to appear. Then you were supposed to again be in court on January the 28th of 26. You failed to appear, and a bench warrant was issued with a no bond hold. And now today, you on February the 6th, you indicated you were going to represent yourself, but today you're just wanting us to address your bond. Is that correct? Or
Yes.
okay, well,
Judge, I didn't understand anything you said, so I chose randomly and went with yes.
Really?
Mr. Bennett, have you applied for a court-appointed attorney?
No.
Do you work anywhere, sir?
I did just in a kitchen.
Okay. Do you have the funds to hire an attorney?
Not really.
All right. Well, so you're not ready to proceed with either a trial request or a plea at this time. Is that correct?
I would like to go forward with the plea.
All right. Well, Mr. Bannon, I'm a little concerned based upon what you've told me here today. And also, apparently on February 6th, you indicated you were hospitalized at St. Joseph the last time you were to appear at a hearing. And you'd said you were in a mental
Regier has deployed the mind bullets. This thing is over.
hospital at St. Joseph.
Yes.
That would also bring me concerns if you're fully capable of representing yourself and so forth. If from what you're telling me finance wise, it sounds like you would qualify for court appointed attorney.
Yeah, probably. I don't know. I just wanted to just tell you the truth about everything that's happened.
Well, before you do that, you understand you have a right.
That's probably not a good idea. I wouldn't recommend it. I also like the, from what you're telling me, it appears that you're broke. It sure does.
To a trial. You're charged with expired tag or registration and no proof of insurance. The first count is a C misdemeanor or unclassified misdemeanor. That's punishable up to a $500 fine, a $500 fine, and up to 30 days in the county jail. Count 2 is no proof of insurance. If you're convicted of that, that's a Class B misdemeanor. That's punishable up to 6 months in the county jail and a minimum fine of $300, but a maximum fine of up to $1,000. But, so it's on that charge, it's very common for people to have a jail sentence imposed. Now, sometimes they're placed on probation, sometimes they're not. Depends on all the facts of the case and their history. but you do have, it's not like if you plead, you may necessarily just walk out of court today.
Okay. I mean, I would just plead guilty. I'm guilty of not having insurance or tags, you know, truthfully.
All right. I just want you to be on the record. You understand you have a right to an attorney.
I told you that's a result of those mind bullets.
And you're waiving that right. Is that correct?
Yeah.
Okay. You understand you have a right to a trial. And if you would make a written request, that could be a trial to a jury. Do you understand that?
Yes, I do.
Okay. And with those things in mind, are you wanting to waive your right to a trial and plead?
Yeah. I plead guilty.
Mr. Regier? Any objection to the court accepting the plea?
No objection, as I do not represent the defendant in these proceedings. I'm a role as prosecutor. If the court is prepared to proceed to the sentencing and disposition in this matter, the state
I'm the prosecutor, you silly judge. Of course, I don't object to somebody pleading guilty.
would request a ruling from the court as to whether or not the defendant has fully waived his right to counsel, and if so, if I have leave to journalize the same.
I do find that Mr. Bannon's waived his right to counsel. I tried to inquire of that and go over the potential penalties with him and the downfalls of doing that. And I believe the defendant knows the potential consequences he faces if he's found guilty. And so I will accept the plea. Mr. Bannon, on or about July the 2nd of 2023 in Butler County, Kansas, did you drive a vehicle without proof of liability insurance?
Yes.
And have driving a vehicle that had an expired tag or registration?
Yes.
All right. I do find there's a factual basis and do find the defendant guilty of those two charges. I'll hear recommendations of sentence at this time, beginning with the state.
Yes, Your Honor. With respect to count one, the state is prepared to recommend a $100 fine and that the court impose appropriate court costs. Although count one does appear to be charged as an unclassified misdemeanor, the state understands that this court has traditionally taken an approach with this type of offense, so the state does not make any recommendations insofar as a jail sentence for count one. For count two, the state is recommending a $300 fine, the minimum required by law, that the court impose a suspended jail sentence of 6 months. The state has no objection to the court ordering a non-reporting probation for a period of 1 year in this matter. And for the court's edification on the issue of jurisdiction, the ticket does appear to refer to the stop occurring on US 54 at milepost 241. The state's information is that is within Butler County boundaries, approximately halfway between Augusta and Leon city limits.
All right, Mr. Bannon, is there any statement you'd like to make concerning sentencing?
I just have a question. So do I have to serve 6 months of jail?
Well, that's what I'm going to decide what your sentence is. That's why I was going before and telling you that what the maximum penalties were. And again, I went through that, there's just because you plead guilty doesn't mean you get released today. You could have a sentence on that count of up to six months. On the first count, you could have a sentence up to 30 days.
Okay. So yes, I do have a 6-month jail sentence.
No, I haven't made that decision.
Okay.
I'm letting you make a statement as to
Yes, sir.
what you think the sentence should be before I pronounce the sentence. First I gave the state their opportunity. They told me what they recommend. Now I'll hear your recommendation.
Well, I would max out the fines that I have to pay, but I need to pay rent on my apartment that I have in Wichita. or else I don't know. I have all my stuff there, and no one knows where I am, currently in my life. So I would really benefit from getting out of here as you know, from I would go full probation. I would do all the fines, even more than what the state has recommended. And
Okay, even I want to step in and help him at this point. I really do. Just leave it to the court's discretion. I got it. You're desperate. You just don't want to. You want to get out of jail. You shouldn't be in jail anyway, based on these charges.
I just need to get out of here so I can make some money. And I would go on probation. I wouldn't. I would report every week. I need to get out of here at least by the middle of March, so that I don't lose my apartment, because I have all my stuff in my apartment. I live by myself. I pay my own bills. I had a job. I need to get it again, because I only thought that I'd be here for a weekend, and it's been 2 weeks, and
Oh my God.
pretty sure I lost that job. So I got a new job lined up, and I'd like to start working that, but that's my statement.
What's this new job you've got lined up?
It's a kitchen job. It's another kitchen job.
Where? What's the name of the
Okay, usually I get irritated with the defendants. This guy is so simple. I really feel sorry for him. Even I do.
business? When can they get you to start?
It's called Dino's, and my friend Miguel works there, that I used to work with, and I called him while I was in here through another inmate here, and he said that I could get in and work with him and get me like $18 an hour. It's Dino's. It's a kitchen.
Okay, so you've through somebody else, you were able to talk with this Miguel, who is not the person who does the hiring. And what would they have you doing at $18 an hour?
Just a line cook. I'd be cooking.
Why? That doesn't surprise me.
Okay, Mr. Bannon, I'm ready to pronounce sentence.
Okay.
Nobody can get help at these places. That doesn't surprise me at all.
Regards to count one, Mr. Regier is correct. I generally don't, on a first conviction for expired tag, I don't generally impose a jail sentence. I'm going to impose a $50 fine. And count number two, I'm going to impose a $300 fine. That is mandatory minimum. I'm going to order a jail sentence of 120 days. You will get credit for the time you've served on this case. This case will be consecutive to other cases that you already may have a sentence on. I don't know that you do or not. Do you?
No, I don't have any
Okay.
other.
I will place you on non-reporting probation. I'm going to assess court costs to you, which on a traffic case are $108. So if I'm adding this up correctly, that comes up to $458. How long will it take you to get that paid?
I could pay it today.
You've got the means to pay $458 today?
Yes.
All right. I'm going to place you on non-reporting probation for a period of 1 year. Since you're telling me you have the means to pay that today, I'm going to give you 30 days to pay it. So I will permit you to be released today.
All right. Did I miss something here? I didn't see any charges that would warrant 120 days. Is it suspended? Judge Lee is a very reasonable, in fact, nice guy. I don't get it.
But a condition of your non-reporting probation is one, no law violations, and that includes traffic misdemeanors. And two, you are to pay that within 30 days.
Yes, sir.
Well, if you fail to do that, if you have a new charge or if you're convicted of something else, that would be grounds to revoke your probation. Please understand, when I impose a sentence, I typically, my position is if somebody comes back and they haven't done what they're supposed to do, I just kind of accept it as they're telling me they'd rather do their time as opposed to, do the things that they were ordered on probation.
Yeah, implicit in this whole probation concept is that it's a suspended sentence and it only gets enforced if you screw up.
So I frequently accommodate them and just and since you have 120 days minus whatever you've already served, I would consider that a fairly significant amount of time. So
Yes, sir.
So I'm going to, so you have 30 days from today to get this all paid in full. I'm authorizing you to be released following this hearing, processed out, and no law violations. So
Yes,
any
sir.
questions about those?
No, sir.
Mr. Regier, any questions?
Nothing further from the state, Your Honor.
Very well. Good luck to you, Mr. Bannon. This matter is adjourned and the parties are free to go.
Wow, that was something. All right. Since I didn't see Biggin going, I just thought I'd dump all the clips I had, which was a lot. Thank you to Zach and Andrea, and I don't know if anybody else sent me this time. I don't know. The stream is so long I can't remember, but it was full of good stuff. And I got to break out my Wyandotte Swingers Club shirt. Wait, how do we do this? There you have it. Thank you all for coming out. I appreciate it. Behave yourselves. I'm not bailing you out. I'm not doing it.